So Peter Showler is one of Canada's foremost refugee experts. Most recently, he served as the director of the Refugee Forum at the Human Rights Research and Education Centre, University of Ottawa, and taught advanced refugee law at the Faculty of Law. Mr. Showler sat on the executive of the Canadian Association of Refugee Lawyers, CARL, and is the current co-chair of CARL's Advocacy Committee. I don't know if that's up to date, but it's...
No, it's not.
No. Yes, and he quit. He quit. He was fired. His perspective on refugee issues in Canada is somewhat unique in that he's been involved in the refugee determination process both as an advocate and as a decision maker. He served as the chairperson of the Immigration and Refugee Board of Canada from 1999 to 2002 and previously sat as a member of the Refugee Protection Division for 6 years. Before going to the IRB, he practiced immigration and refugee law for several years as the co-director of Community Legal Services, a community legal aid clinic in Ottawa. He's the author of Refugee Sandwich, Stories of Exile and Asylum, a book of short stories on the refugee claim process, which I highly recommend. For the United Nations High Commissioner for Refugees, he's worked on the design of refugee status systems in Africa and the international training of refugee status decision makers. Mr. Showler frequently writes and speaks on refugee law issues across Canada, like he's about to right now. Look at that segue, guys. So, Mr. Showler, thank you so much.
Thank you, Julie. I've been coming to Halifax for years because I am a huge fan of the Halifax Clinic as well. What they have managed to do with very limited resources is really quite extraordinary. And for years, they were the first ones to actually do mock hearings with the claimant prior to the hearing itself. It was a brilliant idea. It's now being copied in Toronto. I think it's now soon going to be copied in Ottawa. And an entire area of research has to be done on it because it's quite clear when claimants become more familiar with the process, they are far more effective witnesses. And the results were shown when the the acceptance rates across the country was 32, 35%. The Halifax Clinic was getting results in the low 70s. So it's not just that they're hardworking. They're also very innovative and do wonderful refugee law. So I'm always happy to come when Julie asks. For today, first thing, some of the materials you have in front of you, one of them is called Elements of the Refugee Definition. Lay that aside because I'm going to be talking about that quite a bit. The second one, you'll find one, another one you'll find is Summary of Principles for State Protection. That's just a take-home. There's no way to talk about the complexities of the state law, the law on state protection. So this is something to take home and think about. Maybe this fourth document I'll talk to you about later. The fourth one I have is called Case Study. So I'm not going to be able to do this. And what I'm going to do is speak for 3/4 of an hour on theory of the claim. Later I'll come back to talk about dealing with problematic members. But at lunch, or if there's time later, look at this, and if you've got questions or thought about it, because this is really what I'm talking about with theory of the claim, this is the problem. I'd love to take this problem through the whole presentation, but it'd have to be an hour and a half. But look at that, and if you've got questions or thoughts, and say, well, is that nationality, is it non-nationality, what kinds of persecution is that? That's what this is intended to test you on. So while I'm here, when you read it, if you want to ask me questions, please go ahead. But the topic for today is theory of the claim. And the first thing to say, and how many of you have actually represented a claimant at a hearing? Okay, about almost half, a third. How many of you have not dealt with refugee law in any way where you've had a client and considered, dealt with the client? Anybody in that situation? So you've all got a few. So most of you have at least a preliminary sense of refugee and what it's about. One of the things I usually say is that refugee law and the refugee definition is like Mozart, which is it's easy to play for amateurs and tremendously difficult to play for professionals. Because that's what it's like. In some ways, the definition is very simple, fairly straightforward, and in actuality, when you get into it, because of the complexities of the facts and the fact patterns and the overlapping, all of a sudden it can become tremendously complex and extremely subtle. there are three aspects to the definition, the whole definition, that you'd think about if you were meeting a claimant and you're thinking about the theory of the claim. You first got the Section 96 ground. That's the basic conventional ground, well-founded fear of persecution for reasons of race, religion, etc. Secondly, you've got Section 97. So this is not contained in the convention, but it's contained in our case law, where it's the second or the expanded ground of protection for risk of life or torture, all of those areas. Then the third that you always have to think about is exclusion. So that's the two articles. Article E, where you don't require or deserve protection. You don't have to think about that much. It's very rare. It's only in circumstances where someone basically has a form of protection somewhere else in the world. But you do have to think about Article F, and these are for people that do not deserve protection because they have committed international crimes, crimes against humanity, etc. So those, whenever you speak with a client, whenever you're going through and you have to start to construct your theory of the claim, you would be thinking about all three of those areas. For today, I'm going to limit the presentation only to the first, which is the Section 96 ground, the convention definition, because it's probably less than 5%. I think it's probably around 3% where you'd have to think about an exclusion issue. And at least 85, I don't think anybody knows this, Hillary might, but probably 90%, if your client is going to deserve protection, they will meet Section 96 ground. It's only exceptional circumstances where Section 97 comes into play. So for today, what we're going to stick with is the Section 96 ground. First thing to say is the theory of the claim is by far the most important tool you're going to use as lawyers. That is the tool by which you're going to develop a theory of the claim. You're going to then prepare all your evidence based on that theory of the claim. When you walk into the hearing, you're going to have that theory of the claim clearly set in your mind, and I'll talk about what that full theory of the claim is, and in making your submissions. You will have that theory of the claim, so you will be able to connect the legal analysis and the factual analysis of your claim based on the theory of the claim. And in theory, if you're dealing with a good member, that member should also have a theory of the claim, and members for many years were trained to do so. Somewhat that's fallen apart, especially about 4 or 5 years ago. Now I think they're coming back to working with it more. But in actuality, you should be talking with a well-heard claim, both the member and the lawyer. You may not have certain disagreements about certain aspects of the claim, but you should both be able to have a very clear legal and factual analysis about what the claim is about. So that's why it's the most important tool. And in developing it, it's a two-step process. The first is legal analysis, which I'll primarily focus on today. But then secondly, that's not the whole, some people think that's the theory of the claim. It isn't. The second part is, that's like the skeleton, the bones, and then you put the meat on the bones, and that's the evidence. So you link the evidence to every aspect of your legal analysis. Then that is your theory of the claim. You develop it once you've done you begin by after you've interviewed your client. You develop the legal analysis. You might have to consult some law, and you may also have some information. You might have to get more country information to develop it. So the theory of the claim, even when you develop it, doesn't mean that it won't evolve or adjust, not so much in terms of legal analysis, but certainly if you get more evidence, it may shift your theory of the claim. But in the end of the day, you should be able to say, with the theory of the claim, why your client in law and in fact is a refugee. That's in the end of when you're walking to that hearing, you should have all of that very tightly packed in terms of being able to present it. In terms of now, what I want you to do is take that first document I referred to, if you've got it in front, the elements of the claim, because that's so you can follow along with this. So first of all, in terms of, there are the 6 elements, but the starting point is to remember Every state has this is sort of the substructure, legal substructure of the theory of refugee law. Every state has the obligation to protect its citizens. Secondly, every citizen has the obligation to seek protection from its country of nationality, country of citizenship. That's the starting point. And the concept is called surrogate protection, but refugees, when they seek protection, first of all, they have to leave their state. So a refugee always has to be outside of their country. And then secondly, they're seeking protection from another country, Canada, because they're both unable or unwilling to seek protection of their country. I mean, this will come back. It's important to understand that fundamental concept because it'll come back, particularly when you read the Ward decision on state protection in all kinds of ways. That fundamental thinking, that sort of substrata of legal logic is always going to come back. Okay, looking at that, let me find my section. So what I'm saying is there are 6 elements. In developing your theory of the claim, you need to address every one of these 6 elements. You have to be able to prove every one of these elements in order to establish that your client is a refugee. So the first thing is nationality. You've got to establish their nationality because of what I just said. You first got to look about where they're supposed to seek protection. So the country of nationality is ordinarily the country of citizenship. And in most cases, it's going to be fairly straightforward. They're only going to be a citizen of one country. You're going to know what it is. And all you're usually going to have to think about, and this quite frequently, is how you prove they're a citizen of that particular country. Because at least 50% of refugees arrive in Canada now without passports, often with false documents. So you've got to figure out, are you going to get a birth certificate? And ordinarily, you're not going to be able to get a passport if they don't have it. But you can get birth certificates. There's different kinds of documents. But your starting point, and some lawyers tend to skip over it. Don't skip over it. The starting point is, so you should be able to say, my client is a citizen of this country, no other country, and here's how we prove it. So that's your starting point on the first one. There are some tricky areas in that regard. First of all, you've got to keep an eye out for multiple nationality because you will have clients that will be citizens of 2 countries. And if they are, the law says that they have got to seek protection. Again, it's the same logic. They've got to seek protection from both those countries before they can come and seek protection in Canada. So you may have a very, very strong claim where this person has all these horrible things happen to them in Colombia, and you think you've got a straightforward claim. You didn't pay attention to the fact that in actuality, they're also a citizen of Spain. They're a citizen of Spain, boom, you're out of the game right away unless you can show fear of persecution in Spain. So although it doesn't come up that much, it's something that you have to pay attention to. Every now and again, you will have clients who do not have a country of citizenship. There are, I forget the statistic, it's a lot, in the millions, the number of people that first of all are stateless, but even if you're stateless, you often have a country of habitual residence. So the definition says if you do not have a country of citizenship, then you can claim against your country of habitual residence. I won't spend too much time on it because it's not that common. One thing to know about habitual residence, this is, so it can be any country of habitual residence. It doesn't have to be the most recent one, but you want to be able to show a fear of persecution in that country. You can have instances in that where someone has been stateless, but they've habitual resident for 10 years in a country, but they've been a minority in that country and they've fled it the way any other refugee would flee, because all of a sudden that minority is starting to have troubles there. Palestinians in Kuwait several years ago were a good example of that. So then you show that you have a well-founded fear of persecution in that country of habitual residence. Sometimes with habitual residence where you do not have the right to enter or return to that country, then you're a stateless person. I'm not going to go into statelessness, but statelessness is a different convention. Basically, if you've got someone who's really a stateless person, you're going to be successful, but you're under a different convention, so I won't spend much time on that. The other thing to know about multiple nationality, there is some case law, and I'm not going to spend time on it, but you do have these cases where someone is a potential citizen of another country. An area where it happened a lot were Russian speakers after the collapse of the Soviet Union. They were fleeing places like Latvia, Estonia, the Ukraine, because they were being persecuted there because of their Russian identity. They came to Canada and claimed here. The issue was whether or not, and they came on a Soviet passport, but the issue is whether or not they were also Russian citizens, because if they were Russian citizens, sorry, you don't get to claim in Canada, you get to go back, and they desperately didn't want to go back to Russia. There are other countries where that happens too. So all I can say is that if you have, the case law is a little complicated, it goes two ways, and if you spot something where it looks like there's potential citizenship, and whether or not that can be crystallized or not, this is what I'm going to advise you on a lot of things, go speak to Julie. So what you should be able to do is spot that it's a potential issue. So that's potential or incipient citizenship. So that's your first one. That's your nationality. So you're satisfied. Your client's from Ghana. They've got a passport. So there's not going to be much concern. It's a real passport. So you're not concerned that about citizenship, and you can move on to the second area. So the second area then is persecution. So what you're saying is, okay, they're from Ghana. What harm do they fear? And remember, it's the harm that's going to occur if they go back to Ghana. It's always going to be future harm you're thinking about. So when you're looking at other forms of harm, things that have happened to them, remember that's only evidence to establish, to prove what will happen if they go back, or what could happen if they go back. There is no single definition of persecution. It can be threat to liberty, it can be physical harm, it can be mental harm, it can be a range of combinations. There is no universal definition. By the way, how many of you use the handbook on Refugee Convention? A former student, good. It's online, use it. It's very, very handy. Sometimes you want case law, but the outline of the practice of refugee law and the sort of general authorities are often there. So persecution, that's paragraph 51 in the handbook, where it says that almost anything can be persecution, that there's no one definition. And it also says a threat to life and freedom is ordinarily always persecution. But it's described in different ways, and one of the definitions is defined in terms of a deprivation of fundamental human rights. So the right to life, right to liberty, freedom from torture, slavery, forced labor, freedom of speech, freedom of religion, freedom from discrimination. And Hathaway, and even though the book is a little old, James Hathaway's Refugee Law is still a really, really good base authority for practicing. So if you don't have a copy, maybe he's online now, but certainly the law of refugee status is something, and Jim Hathaway defines it as sustained and serious violation of basic human rights. So that's one way, and it's a very lawyerly way to talk about persecution, was in terms of this violation of rights. The problem I have with it is, particularly when you're arguing a case, even here where it says deprivation of liberty, well, what does that mean? Does it mean that if you're of a particular religion, they put you in jail for one day once a year as some kind of routine thing, and it's only one day in jail in the year? Is that enough to be persecution? I think whenever you're looking at a case, you always look at harm. What is the harm that occurred to and could occur to your client so it's not just the violation of rights, it's actually what's going to happen, what is the consequence because of this deprivation of liberty. And essentially there's two elements that you always look at. There's the gravity of the harm. So what's going to happen is all that's happening is people are insulted. All that's happening is you're discriminated against because of your ethnicity, but it means you can't go to university and you can't be a senior member of government. Not going to university and not getting to the highest levels of government. Can't be a senior officer in the army. is that sufficient to be persecution? Where you say, because of that, I had to flee my country and come to Canada, and Canada protect me. Is that sufficient harm for that? I mean, I think it's helpful to look in that way. So you always look at what the harm is. And the second thing is you always look at, is it sustained? Was it a one-time thing? Could it happen again? So to the degree to which it's repetitive or sustained, you always look at those two aspects of harm. And in general, I'm going to give you a little list that I sort of would go through when I was looking at the harm. First of all, I would look at how serious it is. I already told you that. Some people, you may want to frame it as, you might take the harm and frame it as a violation of human rights. So it's an attack on my physical integrity or my liberty. So you can frame it in human rights, but you're looking at what that harm is. You're looking at its repetition or persistence. You also look at the subjective aspect of harm. If you've got, this may sound a little weird, but if it's that one day a week you have to go do mild forced labor and clean the streets, if your client is a 21-year-old man, that may be very different if your client is an 84-year-old woman with limited capacities. So you always want to think of whatever the harm is it more serious or less serious on your client? You want to think about that. You also want to think about, in the handbook you'll see comparisons between discrimination, which doesn't amount to, I gave you some examples, if you can not be a senior officer, there's discrimination. Or another example of discrimination is you can't go to advanced university studies as opposed to you can't go to school at all. So often there are differences where they separate out discrimination from harm. But there's also this other notion of cumulative persecution. So I can't go to university. I can't be a merchant. I'm not allowed to own land. So if you start to add those up, there is this concept that even though each one of those discrete elements of harm is not sufficient, you put them all together and you can say there's cumulative persecution. So that's a concept you should be aware of, and there's case law on it. But if you start hearing from your client nothing that sounds so terrible, that's when you want to get out your calculator and start adding up all those little grains of sand to see if it adds up to enough that would be persecution. Another thing, and we're going to be talking about this today, to think about multiple forms of persecution. Two things are happening. One, I was arrested in jail because I was at 2 political demonstrations because I'm a member of a party. At the same time, I was kicked out of university because of my ethnicity. One of the things to think about is there are, and this is fairly common with, especially with claimants that come from countries that are quite chaotic, where there's quite a bit of abuse, discrimination, uneven social order. There may be 2, 3, or 4 kinds of harm. Well, don't just necessarily stick them in the same box. Recognize that they're different, because as we're going to see when we go through it, they may have different agents of persecution. There may be different reasons for that harm arising. So you have to be aware of that. But you want to know what all those kinds are. Okay, so that's harm. Any question on that before I go on? I hadn't intended to open up for questions, but is anybody? It's all either compellingly clear or mud. Okay. Let's move on to our next one, which are the reasons for persecution. So this is the causal link. 4 reasons of, and the causal link is really, really important. The harm occurs because of my race, religion, nationality, membership in a social group, or political opinion. That because of is a big deal. This is the way in which the definition was structured from the beginning. It was intended to not provide protection to all kinds of people in horrible circumstances, anything force majeure, floods, hurricanes, anything like that. Poverty, in the original notion of it, general criminality, the way in which your country is falling apart completely, and you would just have common suffering the same as everybody else. It was not intended that you get protection under the definition. There's been some shifts and changes of that in the evolution of the case law, but that was the original purpose of these causes. They were really only, remember, this was created at the same time, just after the Declaration of Human Rights. People were very, in the late 80s after the Second World War, very, very interested in framing out the essential dignity of every human being in the world, and the way in which, if certain rights are infringed upon, you could then come and get protection elsewhere. But it was always intended that it be limited. So let me come back to this notion then. So we've got this notion of reasons for the persecution. Let me come back then to this notion of multiple reasons, multiple forms of persecution. There can be multiple reasons, but there can also be multiple reasons for the same persecution. I am a student in a university where I'm a member of a political club that supports an opposition party, but almost everybody in that party is of a particular ethnicity, and they've got a different minority language. So all of these reasons, am I being persecuted because of being a university student, member of this club, because of political reasons, because of my ethnicity, because of my language? All of those issues can come up. The short answer is this: it might be any one of them, and it doesn't matter as long as it's one of them. As long as have this notion, this harm is feared because of, as long as it fits into one of those categories. And secondly, use your common sense and ask the common sense of your client. Because often it's, well, what is it? The police come because they hate the university students, or is it because of this club, or is it because they'll knock the head of any Tutsi they can get their clubs on? What is it? And they'll often be able to give you the answer. So you follow it by factual common sense rather than any technicality, as long as it's one. Okay, within that, let's look at those 5 categories. The first one is race. Race is pretty simple. It's very broad. It's not specific. Anybody that reads social literature now says nobody has a race anyway. You know, we've got 4% Neanderthal. I've got 8%, but most have 4%. So, you know, race is just, as they say, a social construct. But for us, it's a legal construct. It can be a tribal group, anything that looks or smells like race. That's fine. You can fit it on race. It's a very broad definition. It doesn't have to be technical, narrow, etc. So that's pretty straightforward. The second one is nationality. Again, nationality, it's not nationality the way it is, country of nationality, which is quite narrowly contained within citizenship. This nationality is very general. So as long as you're associated with a country, the Banyamulenge are Tutsi people who have lived in the Democratic Republic of Congo for about 300 years. With the invasion of Rwanda into the DRC, there was a fair amount of discrimination against the Banyamulenge because of their tribal grouping as Banyamulenge, so it could be race, because of their nationality, because they're seen as Tutsi, or because of their political activities, because a lot of them joined in and supported the invading Rwandans. Well, again, you ask your client, and they'll give you a sense of why that militia, that DRC militia, was really coming to attack. But it could be any one of the 3. The most important thing is it's got to be one. So that gives you a sense that it can be fairly broad. The next one is for political opinion. Political opinion is unique in one way. All the other grounds are about identity. You're related to a group, a particular social group. Race doesn't matter, you're related to a group. The only one that's different than that is political opinion. Political opinion could be a group because you're identified with a particular party. But it could also be because you hold a political opinion. And the reason that you're in trouble with the government is because you expressed your political opinion. You're in Tanzania. Tanzania is a pretty mild country, except if you insult the president publicly in Tanzania, you can be arbitrarily arrested and put in jail. So you've got lots of rights there you can talk about, and it's not because you're part of a party, it's because you expressed a political opinion about the president. So it's the only one that can be unique in that way. So it's just worth pointing out that it isn't quite the same as being linked to a group. And the other thing about political opinion. And because you hold the opinion, what becomes very important is evidence, is what evidence do you have of your holding that opinion? Did the police come in and arrest you and say, or here's the list of people? Did you write a public letter? Or have you quietly sitting in your house grumbling about the president for years, but you haven't passed it on? Like, how is it that someone's going to persecute you because of that opinion? So you always then want to get evidence. If they say they hold this opinion, what is it? Are you a member of a party? Whatever it is, you want to link why it is that someone would come and harm you because of that political opinion. The other unique thing, well, that's not in, actually it's, I was going to say it's unique, but it's not in you, but it's generally is, it's the ordinary thought of political opinion is the only one that you can have imputed political opinion. So that notion is, I'm a farmer in a valley where the government knows that the farmers are all giving grain to the rebels and supporting them. And then the government's attacking them, hurting them, burning their fields because they're supporting the rebels. I'm a farmer who hates the rebels. I have no political opinion. I don't support them at all. But there is an imputed political opinion that the reason why they're going to burn my fields too, because it's imputed on me. So, and it's usually arise where there's this imputed opinion. It's ordinarily in political opinion. And the basic principle is the persecution lies in the eye of the persecuted. So it doesn't matter whether you actually hold that opinion or not, as long as you can show that probably that is the opinion of the persecutor. So that's worth thinking about. When I said I'm going to take 30 seconds to say this, I actually had a case. I'm very proud of it, where there can also be imputed race as well. And I had a case in Russia where someone was not Jewish, but I showed that the government was convinced they were Jewish, even though they weren't. So it was imputed race, and that was a successful decision. So it is possible to use it for others, but those are very rare cases. Okay, let's go on to the trickiest of the five, and that's particular social group. Because it's trickiest because it's the vaguest ground. It's basically can be anybody of similar background, social status, habits. It often, again, as I said, overlaps with race, nationality, other groups. The typical ones used to be university students that in El Salvador, the law school, our famous friend Francisco Rico Martinez, who was in the law school in El Salvador at the time, and they had, the entire law school was ringed by armed soldiers. So just being a law student would be sufficient to be at risk. So that would be particular social group, also imputed political opinion. But there can be journalists, human rights activists, teachers in some countries. That insufficient would be a particular social group. But the category has evolved, and it's the Ward decision you can go back to that it creates three categories that you look at in terms of potential political position, potential particular social group. And the most important one is the first one, which is innate characteristics. So an innate characteristic could be race, but race is already covered specifically. But it can be gender, language, sexual orientation. So this was the category, and through Ward, where this huge evolution in the last almost 20 years of the case law in Canada and other places too, where it's because of your gender, domestic violence. Well, you know, you're a beaten wife, you come here, where it used to be, they'd say, well, yeah, but that doesn't fit in with the definition. Well, where it fits is gender. So your particular social group is gender. And there used to be nonsense. Someone would say, well, it's not gender. It's, well, I shouldn't say nonsense. Some say it would be women who are beaten, or women who are beaten in Honduras. They'd want to redefine the social group, make it more specific or less specific. But at the end of the day, it's through a particular social group and being identified as a woman. That's your particular social group. That's the reason why you're being beaten. If you're not a woman, or you can say a married woman, but it wasn't always marriage. That's the basis upon which you're being beaten. And of course, that's in Canada, that's long ago established as solid case law. Same with sexual orientation. You're gay, you're lesbian, you're trans, whichever the category is for which you're being beaten. But your ground, your reason you're being beaten comes within a particular social group. There's a second category of unchangeable category. You don't see it that often. For example, I'm a veteran, I'm a soldier, where veterans in particular countries, all of a sudden, they're badly perceived by the government and they're having troubles. And the reason I'm going to have trouble and suffer harm is because I'm a veteran. Others, sometimes unions that dissolve, but having been a union member. A landowner, certainly with certain countries that became socialist or communist, being a landowner would be the basis for which you were being harmed. There's a third one, fundamental identity or of conscience or human rights that you should not have to give up. So if you're an educator, if you're a human rights activist, if you're an artist, you should not have to give up being an artist because artists are badly perceived in a country. So that can be identified as a particular social group. So those are the grounds. So now we've gone through the country, we've gone through the persecution of the harm. You've now got a sense for why the harm occurred. And remember, if you're building in your little, such as the problem I gave you, you're going to have different forms of harm. It almost becomes, if I'd had sufficient time, just a whiteboard, probably isn't better not right on. Basically, you end up doing a little diagram where you've got three kinds of harm, and then you've got different reasons for that harm occurring, and you just literally build it out like a little chart. Am I at 30?
Yeah.
How much? 10 minutes?
You have 15.
Okay. So let's go on to the next one, which is agent of persecution. For the agent of persecution, it can either be the state agent or non-state agent. If it's state agent, it's not too big a deal because when we get to state protection. However, what you should do is when you're interviewing your client, you should know exactly who those agents are. The police is not good enough. You want to know, are they local police? Are they federal police? Because issues may come up, particularly internal flight alternative. So you want to know who those people, if they're state agents, which particular state agents they are with responsibility. But basically, it's fairly straightforward if they're a state agent. Where it gets tricky is if they're non-state agents, because then there's a presumption the state can protect you. And I'm going to talk about that in a minute. Again, once again, if you've got multiple, with our little chart here, if you've got multiple kinds of harm with multiple reasons, if you've got multiple reasons, you probably also have multiple agents. Some of them may be state agents, some of them may be non-state agents. So chart that out. I cannot tell you, this is so important because half the members at least don't do it. And when they don't do it, they walk into the hearing, and a lot of lawyers don't do it, they're fuzzy. They're fuzzy in their heads. They have not actually figured out exactly what harms are going to happen, for what reasons, and who's doing it, and what the possibilities of that happening. You walk in there, that should be locked in your mind. When I said that your fundamental tool is the theory of the claim, it's also your fundamental weapon if you're dealing with a lousy board member who can't think clearly. You're going to use that weapon to slice through and assist that member in thinking more clearly about the hearing. So that's in terms of the agents, state agent, non-state agent. So let's talk about state protection. State protection ordinarily does not arise if it's a state agent unless there are exceptional circumstances where it's a rogue agent. The only guy that wants to do you harm is the local sheriff in the north of the country. Well, in that case, and this local sheriff doesn't talk to the federal police or anything. So there may be something like that. You may have to think about state protection elsewhere, IFA. So that's a local sheriff. Or the other thing is if you've got a rogue agent who is not really acting on behalf of the government. They've got a thing, they're going to get you because it's very personal, and they're not really acting on behalf of the government. But those arise very rarely. So basically you think if you've got a state agent, you don't have to be so concerned about state protection. Where you do have to be concerned is if it's an unstate agent, because the basic rule is there's a presumption that the claimant has protection, and it is the claimant's burden to show that they cannot seek state protection. And the language used from Ward was clear and convincing evidence that the person cannot obtain protection. And that caused all kinds of problems. I think I'm going to leave you with the statement of principles because of time now, but I will say the fundamental issue is this: overcoming the presumption. So the claimant has to show on a balance of probabilities that they cannot obtain protection. And there's basically two ways of doing it. The first of all, showing similarly situated people. So that would be in circumstances. So I'm a merchant from an area of Honduras. The cartels have already killed 3 merchants who have not paid the bribes. I have been demanding bribes. I've paid them. I've stopped paying them. So the similarly situated evidence is other merchants who've been killed, other people. So that's the one way to prove it. The other is past personal incidents. So they came and threatened me. They already beat me up once and said, next time it's going to be worse than a beating, it's going to be a killing. So any of my past experience. In general, I'm going to say this, and this is a recommended approach. You can look through the case law, but here's the problem with state protection. You have lots of decisions who focused on it being a democratic country with this notion, principle, if it's a democratic country, well, you can't protect everybody. The police can't be perfect. Just because you're at risk doesn't matter, because it's democratic. Well, Afghanistan's democratic. Colombia's democratic. Lots of very dangerous countries are democratic. But that's the one approach in the case law. At the other end, you've got the ones that focus on the dangerousness of the country, the way in which, even though it's democratic, the place is falling apart. Mexico, it's democratic, but there's so many corrupt police in that. So you focus on the way in which it's not a fully functioning democracy, and you focus on the inability of your client to access that protection. Classic example would be, again, domestic violence, where yes, there are some people that get protection from the police, but the police don't give a damn about beating women. Your client's poor, she's uneducated, she has difficulty accessing it, or she goes and asks once and they laugh at her. So there's been 5 more incidents of horrible domestic violence. She didn't go again. So there's in all this case law of what you emphasize. But I've given you the principles, and I think that you stay with those, except that you look at, basically, what I say is you look at the nature of the harm, the violation of the rights, the profile of who's doing the human rights abusing, the cartels, the amount of control they have in the country, the efforts of the victim to seek protection, the response from the authorities, and the objective documentary evidence. You'll find that in those documents in the Torres and Lezama decisions. And I recommend you take that as a starting point if you've got a serious state protection problem. I'm just going to skip over IFA. It's a 2-pronged test. It's pretty standard. If there is an internal flight alternative, clients got to show that there's some part of the country where they still cannot have protection. The basic rules are the board member has to specify the internal flight alternative. It just can't be somewhere else in India, because that's 50. They have to specify it, and then there's the 2-pronged test. First of all, is there a possibility that I could be harmed, persecuted there? And even if it's that I could not be persecuted, that it wouldn't happen there because they don't know me, is it reasonable in all the circumstances for me to relocate there? And there's significant case law on that. The reason I can't go is because I'm an 85-year-old lady. I don't speak the language. It's a different religion. Women can't live alone in that particular tribal area, etc. So there's a ton of case law on it. But you always just want to think, if there's no state protection available, is there a danger? This is the kind of country, and you will know the country information. The countries are known where there are IFA issues. So I want to go on to number 6, which is well-founded fear. So this is the 6th element, and in a way, this is the element that ties everything else together. So you figured out who they are, where the harm is, why they're doing the harm, who's doing the harm, then it's the well-founded fear. So there's two aspects of it. Fear is the subjective aspect of the test, and whether or not it's well-founded, objective. So, and I'm conscious of saying this with Dr. Graham here. She's written papers on this stuff. And I think we have the same point of view, but sometimes I worry about it. In any event, the subjective aspect of it ordinarily should be no big deal, but you do have to pay attention to two things. If your client, first of all, after the precipitating incident for which they say they fled their country, because the police came around and said, that's it, when we come back, we're killing you and your family. If they remained in the country of nationality for a significant period, after that, it's called delay in departure. There are wacko members, and there's lots of them, and wacko federal court judges who go, oh, well, they don't have a fear of persecution. They didn't leave. So you want to ask questions about why they stayed if that comes up. The other one is delay in claiming. Stayed in the States for a year, didn't claim there, and then came up. Came to Canada and didn't claim for 6 months. Again, these are issues that can be overcome, but you want to ask the evidence why they did not claim right away. Often there's excellent reasons why they didn't do these things, but as a lawyer, you think about that as a danger point, and in terms of your theory of the claim, you want some evidentiary responses for that. But the other aspect then is whether or not it's well-founded. So is there an objective basis for the claim? And this is the AJ test. And essentially, I've tried to explain this to a group of Japanese lawyers a year ago. And something that I think is now so straightforward. They're looking at me, I might as well be from Mars. There was no, it just doesn't compute the way in which their rational analysis, and they have the same definition we do. In any event, what for the twofold test is, first of all, on the balance of probabilities, subjective and objective, you establish the facts of the case. So all of that is found on a balance of probability. Is it probably true that I'm Ghanaian? Is it probably true that I was a member of this political party, etc.? And you've got all your evidence to support that. So that's your first step. You establish what is, in your view, provable, with evidence to prove it in terms of the fact. So that's the first thing to do, including whether or not they have a subjective fear. So you establish that. So that's all on the first part, which is really the factual basis of it. And then you go to the next step, which is risk analysis. Given that this is true, that I'm a Ghanaian, member of this party, this is the COI in the country and everything, is there a reasonable chance, or more than a mere possibility, because that's exactly, the Ponius decision says they mean the same thing. Is there a reasonable chance that I could be persecuted or harmed when I return? So that's your crunch question. All of this logic leads down to that at the end. Is there just a reasonable chance? And it's a risk analysis. I mean, Hillary's written endlessly on this stuff, but these are future events, given all the past things, that I could be persecuted, except you're more specific. You're saying, is there a reasonable chance that I could be arbitrarily detained? In other words, is there a reasonable chance that I could be shot and killed? That I could continue to be discriminated against? You would do that analysis in your own thinking for each one of those harms that you've already crafted out. There only may be one harm, there may be 2, 3, or 4. So you know what the risk is for each one of those. Because you may have something with an extremely serious harm, being killed, but the chance of that happening may not meet the risk test, whereas you've got other forms of harm that are less, but clearly meet the test. So that's the analysis that you do. So that is the theory of the claim. That's your legal analysis. Once you've done that, you do the, as I say, evidentiary assessment, where you go back and you look at all of those things. You look at the COI, you think about all the ways in which you can prove every one of those elements. And that includes personal documents, the passport, or all kinds of other personal documents. I've got a professor's card that says that I'm a member of the university where they're shooting the professors, whatever. Lots of personal documents. Secondly, all the COI, and you all know about COI, country information documents, not just from the board, it can be anywhere from all over the world. Medical reports, corroborating witnesses, experts, and don't forget, often the most important, and sometimes it shouldn't be the only one, the testimony of the claimant themselves. But what you do is go back and every one of those elements, how you ask yourself the same question, how do I prove that? How do I prove that? How do I prove that? And once you've gone through that process, then you have your theory of the claim. And you will have strengths and you will have weaknesses. And that's why I say it can evolve. You say, this isn't going to make it unless I find some other means of establishing that my client was involved with this particular political group. And then you maybe go look for a corroborating witness, whatever. But you've already got your theory of the claim when you do it. That's it. Thank you.